There is no question put whatsoever. She has just told them that he needs to put that question again. There is no question put. So what were these members voting for or against? There is no question put. Honorable Senators, we then need to sit here and invite witnesses on the stand to demonstrate that there was no proceedings that took place.
If somebody brought before this House a Hansard that is not certified, because certification is done by a particular officer whose signature we can tell, is what is before you a Hansard of the County Assembly of Isiolo or a mere piece of paper? Validity of another motion has been impugned on two grounds. One, there was no sitting known to law of the County Assembly of Isiolo to approve the motion. And number two, in any event, a court of competent jurisdiction has made a finding that whatever came from the County Assembly of Isiolo is null and void.
We proceed to the Hansards now of 26 when the governor is being purportedly impeached. That's at page 23 of the same document. There is a communication from the chair. The first order of business, you will come across the order paper at page 17, where we have a total of 8 orders of the day. 8. But when you go to page 23, we do not see the clerk calling out the orders. Just look at it. It is the speaker directly proceeding to make a communication. Is that an anomaly, Honorable Senators? We are all familiar with the business of the day. But what intrigues me more, Honorable Senators, the first order of the day here is to lay on the table the purported public participation report, which is done by Honorable David Lemantile, allegedly. He prosecutes his motion and argues on the public participation. Let's go to the end at page 31. But before that one, let's go slightly at page 30, where he completes his submissions. After laying the paper, public participation, we now see Honorable Peter Losu standing up to second this motion. Who has invited him to second this motion? Out of nowhere, he's not invited by anyone, but Hansards show that he rose to second this motion. And then the speaker proposes the question and it opens the floor to the members of the House. At page 31, the last member seen to be speaking is Honorable Francis Letimalo. The speaker now puts the question. So what happens after the question was put, Honorable Senators? There is no record whatsoever of what transpired. Nothing. A question is put. There is no indication that the House actually endorsed the public participation report. That Hansard is left hanging. After that paper is laid, the speaker does not even call for the next order. The clerk is not seen anywhere calling for the next order. Instead, what do we see? Honorable Abubakar Godana is seen now on the floor. Hansards are supposed to be capturing verbatim what transpired. So who was in charge of this House? Where is the speaker's recording inviting the mover of the motion to move the motion? Where is the recording of the clerk inviting, or rather calling for the order, for the next order? There is nothing. Instead, we just see someone on the floor prosecuting the motion. And he proceeds and proceeds. At page 35, he's done. Strangely, the first paragraph at the top of page 35, when he completes to execute his motion, he does not invite anyone to even second. Records are there. But we see one Honorable Major Golicha now standing up to second the impeachment motion. Who has invited him? There is no one. And other members, strangely now, so the House is suddenly in an autopilot. So from Honorable Major, then we see the Speaker opening the floor. You have Honorable Peter Losu. He continues. Without the intervention of the Speaker, there is another member, Honorable Salesio Kiambi, who proceeds as if the Speaker is not in this House, as if the clerk is not in this House, and proceeds. Another member just rises up from nowhere. There is no recording of the Speaker inviting any member to make a contribution to this motion. Apart from, of course, page 39, when suddenly the person cooking this answer realizes the Speaker has not been captured in this, and now we see the Speaker for the first time. In conclusion, because I do not want to take time that my senior is going to take to address you on the other issue, look at page 41. After the members purportedly complete to make their submissions, the Speaker makes very strange remarks, and I quote at page 41. Clerk, is the Governor or his legal representative available? Sergeant at Arm, can you check around if the Governor or his legal representative are present? The Speaker does not even take time to communicate to the House whether the Governor had been invited. He does not even read that invitation notice as required. So why is he calling for the Governor, whom Learned Counsel had told you was invited to appear at 9 and we at 2 o'clock? The Speaker is not seen anywhere saying that we invited the Governor by this letter and he has not come, but instead asked the clerk to check whether the Governor is available anywhere. Let's proceed. I'm completing, Honorable Senators, and this is going to shock you. So, when the Governor was confirmed was not in the House, the Speaker proceeds to guide the House on the next move. At the end of that page, 41, I read what the Speaker says. When the doors, I'm reading the last part, when the doors have been locked and the bar drawn and the names of the tellers have been announced, the Speaker shall, this is the Speaker telling them, the Speaker shall put the question again in the presence of the tellers. When called out, each member shall thereupon rise in his or her place and declare assent or dissent to the question in the following manner. I vote yes or I vote nay. Proceeds. Honorable Senators, page 42. Where does the Speaker put that question to the members of the House present? There is no question put whatsoever. She has just told them that he needs to put that question again. There is no question put. So what were these members voting for or against? There is no question put. Honorable Senators, we then need to sit here and invite witnesses on the stand to demonstrate that there was no proceedings that took place on 26th and 18th. I rest my case.
Thank you, Mr. Speaker, and thank you, distinguished senators. I'll proceed to argue the final limb of the objection, but just to cap up what my learned colleagues have told you, that if before you is a purported Hansard in the form and content that you have been taken through, if before you is a purported Hansard that no one has taken the courage of his or her conviction to certify, if somebody brought before this House a Hansard that is not certified, because certification is done by a particular officer whose signature we can tell, is what is before you a Hansard of the County Assembly of Isiolo or a mere piece of paper? And if we conclude, as I invite you to, that what is before you is a mere piece of paper, to the extent that it is not certified, can we take any other proceedings on the strength of that mere piece of paper? That is what makes this issue a proper preliminary objection for resolution, one way or the other, before we can go into the trial. Secondly, is the issue of the order of court. And I want to address this issue as follows. We are guided by the Constitution and other laws and the standing orders, and to an extent, the manuals that this House publishes from time to time to inform both these members and the members of the public who interact with this House. My research has revealed that the latest manual issued by this House is a manual entitled Removal from Office of County Governors and Deputy County Governors through Impeachment, an easy-to-use manual on the procedures and rules. That manual, on the face of it, was published by the Directorate of Legal Services and the Senate Liaison Office in the year 2025, which is this year. Part 3 of that manual is entitled Judicial Proceedings Against Impeachment. And this is the position this House has communicated in that manual at page 60, which is the very last page of that manual. There are 2 subtitles at page 60 of that manual, which is subtitle 1, Comply with Court Orders. And it says, parliamentary privilege and immunity and the principle of separation of powers do not shield the county assemblies and the Senate from court orders. When court orders are issued, they are binding on the county assembly and the Senate and must be complied with. Failure to comply with court orders may result in the invalidation of the entire process of impeachment by the courts. Then the second subtitle is participate actively in court proceedings, and this Senate has communicated to us through this manual that ignoring court orders against the county assembly or the Senate is not the solution. If court orders are issued against a county assembly or Senate, the most preferable option is to participate actively in the court proceedings. The county assembly or Senate may apply for review of the court orders or appeal to the next court for variation or the setting aside of the court orders. That is the manual that this House has published as late as this year. Allow me to make the following submissions then. The existence of the orders of court I am going to refer to is not a disputed fact. It is a fact admitted by the county assembly in their written submissions. So the existence of these orders is not a contested issue. And it not being a contested issue, it follows therefore that this Senate can proceed right away to resolve the question of the impact of those orders without investigating whether they exist or they don't exist, because between the parties, it is an admitted fact. Allow me to begin by referring this order, this Senate, my apologies, to an earlier ruling of the Speaker of the then only House of Parliament, which was the National Assembly before the new Constitution. This was the ruling by Speaker Kenneth Otiato Marende on the question of nominations of Chief Justice, Attorney General, Director of Public Prosecutions, and Controller of Budget, and that ruling was made on the 17th of February 2011. It is found in volume number 4 of the governor's documents. It is found in volume number 4 of the governor's documents, and you'll find that ruling starting at page 165 of volume number 4 of the governor's documents. But the relevant part I will refer to in the interest of time is at page 168 of that volume, volume number 4 of the governor's response. At page 168 is a continuation of that ruling of the then Speaker of the National Assembly, Honorable Kenneth Otiato Marende. He says, and I quote, "Honorable members, between the time when Mr. Imanyara first raised the matter and now, I have had the benefit of considering a range of material addressing the various aspects of the matter. Specifically, I have benefited from, among others, the position taken by the Judicial Service Commission, the Commission on Implementation of the Constitution, and the Law Society of Kenya. I have also carefully read and considered the ruling of the High Court relating to the matter of nominations, which was delivered on 3rd February 2011. Mr. Speaker, distinguished senators, I had the rare privilege of participating in that court proceeding. The first three of these bodies are constitutional or statutory, and their views on matters of law, though not binding to this House, are of significant persuasive value. Honorable members, as for the ruling of the High Court, despite my restatement of the constitutional relationship between the legislature and the judiciary, I have repeatedly emphasized that subsisting judicial decisions, while they cannot restrain the legislature, and that's important to us because I'm addressing this issue, while they cannot restrain the legislature from the discharge of its functions, are of binding effect and may have a bearing on the products emanating from this House. The learned Honorable Justice Musinga, in his ruling in the above case, found that the nomination of the Chief Justice was unconstitutional, for it was not in accordance with Article 166 of the Constitution. I will then proceed to page 169 of that volume in the interest of time. The paragraph starting with honorable members, that will be the third paragraph. Although I have read that this court decision does not stop the National Assembly from proceeding with its work and cannot determine for the House how to proceed, it must be noted, as matters currently stand, any decision made by this House on the nomination, though perfectly procedural from the point of view of the legislature, outside the legislature, it is, to the extent that it does not accord with the ruling of the court, null and void for all purposes. So that is the guidance that Honorable Marende makes. Allow me to then come to the specific ruling that we wish to draw this Senate's attention to, and that I will refer you to volume number 4 still. Thank you so much, Mr. Speaker. And as somebody who has been here multiple times, I'm always impressed by the support we get from the administrative teams in this Senate. That may have to go on record in the interest of posterity. At page 13 of volume number 4 is a decision of the court in Isiolo High Court Constitutional Petition number A004 of 2025. The parties are Honorable Abdi Ibrahim Hassan, the governor now before you, as petitioner, and the County Assembly of Isiolo, now before you, as the first respondent. There are two other parties in that matter, but safe to highlight that the parties before you are parties in that suit. They are therefore bound by the decision of that court. At page number 25, allow me to just go straight, Mr. Speaker, to page number 27. You'll find a paragraph 28 of that ruling. And the judge observes as follows: it is important to note that there was no complaint raised when the first orders were issued by the court in respect of the motion dated 10th June 2025 that was to be debated on 17th June 2025. In fact, the sentiments by the mover of that motion, the contemnor, actually vindicates the court, as he has in his affidavit conceded that the motion was defective in substance and marred with procedural irregularities, the very grounds that the petitioner has sought to rely on. The mover of this motion went to court and told the court, it is true that the orders you gave first were right, because the motion I had tabled was marred. It was defective in substance and marred with procedural irregularities. The move of the motion. Allow me to then take you to paragraphs 45, 46, and 47 of that ruling at page number 35 of volume number 4. Paragraph 45, the judge says, therefore, it is the finding of this court that the motion dated 18th June 2025 and debated by the first respondent on 26th June 2025 was in contravention of the conservatory orders of this court issued on 25th June 2025. Hence, the resolution arising therefrom is null and void. Once an act is declared null and void, it is of no legal consequence. A court of law has found that this motion, which has now been brought here before you, senators, is null and void. It is of no legal consequence. Paragraph 46. As stated, the resolution has evidently been submitted to the Speaker of the Senate. It is thus upon the Senate, once informed of the orders herein, which I'm now doing, Mr. Speaker, distinguished senators, to determine if it will proceed to handle the said resolution, thus abating a blatant disregard of the rule of law or the respect of orders. The matter at hand calls for a stand to be taken by the constitutional organs involved. What they choose to do will have set a precedent on the necessity for compliance with court orders. It is a choice between anarchy and constitutionalism. Distinguished senators, the judge is saying this. The judge is saying, I am aware. I cannot stop you from doing your work. So he's saying, proceed and go to Senate. And that, to my mind, was an extremely wise move by the judge, considering historical pleas for there to be institutional committee between institutions and to respect the powers of each organ. But the judge is saying, so you decide for yourselves how you will proceed. I have made a finding that that motion is null and void and of no effect. I want to contradistinguish this with other scenarios that the other side will draw your attention to shortly. The judge has not issued a conservatory order against this Senate. The judge has made a determination on the validity of the motion purportedly debated and purportedly approved by the County Assembly of Isiolo. The judge has made a determination. It is null and void and of no legal consequence. You are being invited to engage with this motion on that strength of fact on the strength of the finding by the judge that the motion as approved, as brought before you, is null and void and of no legal effect. We therefore invite you to introspect and make this determination. When the impeachment law calls upon you to determine a motion that has been approved by the county assembly, is it just any motion or a valid motion? If there is information before you that the motion is invalid for any reason, what is the precedent that has been set by this Senate? It is against that background that I wish to draw this Senate's attention to its resolution that is found from pages 136 of volume 4 of the governor's documents. And this was the determination of the proposed removal from office by impeachment of the governor of Kericho County, Honorable Dr. Eric Kipkoech Mutai. On that occasion, the validity of the resolution was questioned on the ground that the motion had not met the threshold. And rightly, this House found that it could not move a step further because validity of the motion is an important precondition to the carrying out of the trial process on the motion. Similarly, by parity of reasoning, today, validity of another motion has been impugned on two grounds. One, there was no sitting known to law of the County Assembly of Isiolo to approve the motion. And number two, in any event, a court of competent jurisdiction has made a finding that whatever came from the County Assembly of Isiolo is null and void and of no legal consequences. Will you, in the face of the precedents you have set by previous speakers' rulings and by resolution in the case of Kericho County Governor's case, proceed to trial on that understanding? We beseech you with humility to find that there is no motion known to law before you and thereby to down your tools. I humbly submit and respect and rest the governor's submissions on that question of the preliminary objections. I reserve our 10 minutes, Mr. Speaker, for a rebuttal from this side once the County Assembly has finished their response.